Green Card Marriage Rules, USA, 10 Shocking Facts Couples Ignore. Think getting a green card through marriage is simple? One small mistake could destroy your American dream forever, and thousands of couples learn this the hard way every single year. Hey everyone, welcome back to the channel. If you're planning to marry a US citizen or already have, you need to watch this entire video because what I'm about to share could save you from deportation, massive fines, or even criminal charges. I've researched the most overlooked rules that immigration officers are watching for, and some of these facts will absolutely shock you. Before we dive in, make sure to hit that subscribe button and ring the bell so you never miss crucial immigration updates. Let's get started. The first shocking fact is about the conditional green card trap. Most people don't realize that when you marry a US citizen and have been married for less than 2 years, when your green card is approved, you don't get a permanent green card right away. You get what's called a conditional green card that's only valid for 2 years. Here's where couples mess up badly. You must file Form I-751 to remove those conditions within the 90-day window before your 2-year anniversary. Miss this deadline even by 1 day, and your green card becomes invalid automatically. You could be placed in removal proceedings immediately. I've seen couples who forgot about this deadline because they were busy with life, had a baby, or simply didn't understand the importance. The government doesn't send you reminder letters. It's your responsibility to track this date. Even worse, if you're divorced by then, the process becomes incredibly complicated, and you'll need to prove the marriage was genuine despite it ending. This catches thousands of people off guard every year. The second fact that destroys cases is inadequate proof of a genuine relationship. USCIS doesn't just take your word that your marriage is real. They're specifically trained to detect fraud, and they're really good at it. You need overwhelming evidence that you share a life together. I'm talking about joint bank accounts with regular transactions from both parties, joint lease or mortgage documents, utility bills in both names, joint car insurance, health insurance, beneficiary designations, photographs together spanning your entire relationship with family and friends, travel documents showing trips together, an affidavit from people who know you as a couple. But here's what most couples ignore: the quality of evidence matters more than quantity. Having 50 photos from your wedding day means nothing if you can't show pictures of normal daily life together over months and years. Immigration officers look for signs of a paper marriage. If you got married quickly, live separately, or can't demonstrate financial entanglement, red flags go up immediately. One couple I know had their case denied because even though they had a joint bank account, only one person ever made deposits or withdrawals. That looks suspicious. The officer questioned whether they really shared finances or just opened an account for immigration purposes. The third shocking fact involves the marriage interview itself. Both spouses must attend this interview together, and it's way more intense than people expect. Officers are trained in interrogation techniques. They'll separate you and ask identical questions to see if your answers match. What side of the bed does your spouse sleep on? What time did your spouse leave for work this morning? What did you eat for dinner last night? What toothpaste brand does your spouse use? These seem like silly questions, but if your answers don't align, the officer assumes you're lying about living together. They'll ask about intimate details of your relationship, your daily routines, your future plans, how you met, who proposed, and what you did on your last anniversary. Some officers will deliberately create stress during the interview to see how you react. They might accuse you of fraud outright to gauge your response. Couples who aren't genuinely married often crack under this pressure. Snorts. But even real couples fail if they're not prepared. Maybe you're nervous and can't remember details. Maybe you have different perspectives on the same event. Maybe language barriers make communication difficult. You need to practice beforehand, but without memorizing scripted answers, because that also looks suspicious. It's a delicate balance. The fourth fact is about the financial sponsorship requirement that can haunt you for years. The U.S. citizen's spouse must file Form I-864, Affidavit of Support, which is a legally enforceable contract. You're promising to financially support your spouse and you're agreeing that they won't become a public charge. Here's the shocking part. This obligation continues until your spouse becomes a U.S. citizen, works for 40 qualifying quarters, which is about 10 years, dies, or permanently leaves the United States. Even if you get divorced, you're still financially responsible. If your immigrant spouse receives certain government benefits, the government can actually sue you to recover those costs. I've seen cases where someone sponsored their spouse, got divorced after a nasty breakup, and years later got sued because the ex-spouse received welfare benefits. The sponsor had to pay thousands of dollars back to the government. Additionally, you must meet income requirements of at least 125% of the federal poverty line for your household size. If you don't meet this threshold, you'll need a joint sponsor who also signs the I-864 and takes on the same legal obligations. Many couples don't take this seriously until it's too late. The fifth fact involves criminal records and their devastating impact. Any criminal history, no matter how minor you think it is, must be disclosed. Immigration officers have access to FBI databases and international criminal records. If you lie or omit anything, that's immigration fraud, which is a separate crime. Snorts. Even minor offenses can affect your case. Domestic violence charges are an automatic bar. Drug offenses, even marijuana possession in states where it's legal, can cause problems because it's still federally illegal. DUI convictions raise questions about moral character. Multiple traffic violations might seem insignificant, but paint a pattern of disregarding laws. Here's what couples ignore. Both the U.S. citizen and the immigrant need to disclose their criminal histories. A U.S. citizen with serious criminal convictions might not be able to sponsor their spouse. The immigrant could be inadmissible based on their own record. Some crimes can be waived, but you need to apply for a waiver and prove your case deserves an exception. This requires extensive documentation and often legal representation. Trying to hide criminal history is the worst possible approach because when it's discovered, and it will be, your credibility is destroyed and your case is likely denied. The sixth, shocking, fact is that social media surveillance is very real. USCIS officers routinely check Facebook, Instagram, Twitter, TikTok, LinkedIn, and other platforms. They're looking for evidence that contradicts your application. Did you claim to be living together, but your social media shows you tagged in different cities constantly? Did you say you've been in a relationship since a certain date, but your Facebook status shows something different? Are there photos of you in romantic situations with other people during the time you claim to be exclusively with your spouse? Are there posts or comments suggesting the marriage is for immigration purposes? I've heard of cases denied because someone joked on social media about marrying for a green card. The officer took screenshots and used it as evidence of fraud. Even private accounts aren't safe because friends or family members might have public posts that tag or mention you. Privacy settings can be changed, but old posts might already be archived or screenshot by the government. Some immigration attorneys now advise clients to scrub their social media or make everything private months before applying. But deleting posts after filing your application looks suspicious too. The best approach is to ensure your entire digital footprint supports your genuine relationship claim. Post photos together, check in at locations together, interact publicly as a couple, make your online life match your application. The seventh fact that couples constantly overlook is about previous marriages and divorces. If either spouse was married before, you must provide complete divorce documentation proving those marriages legally ended. Immigration officers verify this carefully because if any previous marriage wasn't properly terminated, your current marriage is invalid. That means your entire green card application is based on a fraudulent marriage, even if you didn't know about the legal problem. I've seen heartbreaking cases where someone thought their divorce was finalized, but there was a procedural error, and years later their green card case was denied. You need certified copies of divorce decrees, not just regular copies. If the divorce happened in another country, you might need certified translations and verification that the foreign divorce is recognized in the United States. Some countries have complex divorce procedures that take years. If you remarried too quickly, immigration might question whether the previous divorce was legitimate. Also, if you've been married and divorced multiple times, especially to U.S. citizens, that's a major red flag suggesting a pattern of marriage fraud. Officers will scrutinize those cases much more carefully. The eighth shocking fact involves the danger of living apart. Immigration expects married couples to live together. If you and your spouse maintain separate addresses, you better have an incredibly compelling explanation. Common reasons include military deployment, job requirements in different cities, or caring for sick family members, but you need documentation proving these circumstances. If you claim your spouse works in another state, provide employment verification, pay stubs, lease agreements. If you're separated for legitimate reasons, show evidence you visit each other regularly, like plane tickets, phone records, and receipts. What immigration doesn't accept are cultural explanations about living with parents or vague claims about planning to move in together later once you're married. Especially after the green card is approved, you must live together as a married couple. During the I-751 process to remove conditions, living separately is extremely problematic. Officers assume you got the green card and then abandon the marriage. Even if you have a good reason, you'll face intense scrutiny. Make sure you can prove the marriage remains genuine despite unusual living arrangements. The ninth fact is about the consequences of divorce during the immigration process. If you get divorced after filing for a green card, but before approval, your case is typically denied unless you can prove extreme hardship or abuse. Even after getting a conditional green card, divorce before removing conditions creates major complications. You'll need to file for a waiver proving the marriage was entered in good faith, meaning it was genuine at the start, even though it ended. This requires extensive evidence like wedding photos, proof of cohabitation, joint financial documents, testimony from friends and family, and documentation of the relationship timeline. The burden of proof is entirely on you. Many people assume that once they have a green card, they're safe. But with a conditional green card, divorce puts you at serious risk of losing your status. Now, if the divorce is due to domestic abuse, there are special protections under the Violence Against Women Act that apply to all genders. You can self-petition for your green card without your spouse's cooperation, and the abuse must be documented through police reports, medical records, restraining orders, or affidavit. But this is a complex legal process that requires careful handling. The 10th and final shocking fact is about marriage fraud consequences that can destroy your entire future. If USCIS determines your marriage is fraudulent, the penalties are severe and life-changing. The immigrant faces permanent inadmissibility to the United States, meaning they can never get any immigration benefit ever again. They'll be placed in removal proceedings and deported. They could face federal criminal charges with up to 5 years in prison and fines up to $250,000. The U.S. citizen spouse also faces criminal prosecution for conspiracy to commit immigration fraud with the same penalties. Both parties could be ordered to pay back any benefits received. Your name goes into immigration databases flagged for fraud forever. This affects any future travel or immigration applications anywhere, not just the U.S. Even if you later genuinely fall in love and marry another U.S. citizen, your previous fraud makes you permanently inadmissible without a waiver that's almost impossible to get. I cannot stress this enough. Immigration fraud is a federal crime that follows you for life. It's not worth the risk. If you're considering a fake marriage for a green card, don't do it. If someone approaches you about participating in one, absolutely refuse. The government investigates these cases aggressively, and informants often cooperate to reduce their own penalties, meaning your partner might turn you in. So, those are the 10 shocking facts about green card marriage rules that couples constantly ignore. The bottom line is this: getting a green card through marriage is a legitimate path for genuine couples, but it requires careful preparation, honest documentation, and thorough understanding of the process. Immigration officers are trained professionals who investigate thousands of cases. They know every trick and every red flag. Your best strategy is complete honesty, overwhelming evidence of a genuine relationship, and attention to every procedural requirement and deadline. If you're going through this process, consider consulting with an experienced immigration attorney. Yes, it costs money, but a denied application or removal proceedings cost far more in terms of money, time, and emotional devastation. An attorney can review your specific situation, identify potential problems before they become disasters, and present your case in the strongest possible way. I hope this video helped you understand the serious aspects of marriage-based immigration that many people overlook. If you found this valuable, please give it a thumbs up, share it with anyone who might benefit, and let me know in the comments if you have questions or experiences to share. Subscribe to the channel for more immigration insights and updates. Thanks for watching, and I'll see you in the next video.